Good evening, student loan slayers. Welcome to Lesson 5 of Slay Student Loan Debt 101. My name is Natalie Jean-Baptiste. I'm a bankruptcy attorney, adjunct law professor, and student debt relief advocate. I wiped out 6 figures of my own student loan debt through the bankruptcy process, and I've been on a mission to liberate others from student loan debt ever since. This is my favorite topic to teach because I think it's the most powerful and underutilized tool when it comes to slaying student loan debt. And with that, let's get into lesson 5. So for those of you who are just discovering this course, I just want to give you a course overview of what we've covered so far. And you can go back to the previous lessons if any of these topics resonate with you and these are topics that you need to learn more about. So in lesson 1, we covered the fundamentals of student loans. In lesson 2, we went over repayment options and the best strategy that makes sense for your situation. And then in week 3, we discussed loan forgiveness. And last week, we discussed delinquency and default. And tonight, I'll be discussing how to discharge student loan debt in bankruptcy. So this is just a brief overview of what I'm going to cover tonight. First, I'm going to talk about the basics of bankruptcy law. Then I'm going to look at the different chapters, chapter 7 versus chapter 13. Then I'll discuss how student loans are treated in bankruptcy. And next, we'll cover what does undue hardship mean and what do you need to do or what criteria do they look for to see if you qualify for an undue hardship discharge. And finally, I'll discuss how you can work with me in the future. Also, there's going to be a bonus live Q&A that's going to be next week, Wednesday, March 12th at 8 p.m. So please save the date for that. And in that, it's going to be live on TikTok, and you will have the opportunity to ask your questions, and you can send me your questions in advance via email or DM as well. So let's talk about what bankruptcy is and what it means and what it does. So most people's concept of bankruptcy is what they see on TV and in the movies, right? So, when you watch Wheel of Fortune and somebody gets the bankruptcy, it hits the bankruptcy wheel, it's like, oh no, that's the worst thing ever, the end of the world. And that's absolutely not true at all. Bankruptcy is actually a great tool for giving someone a fresh start and a clean slate to start over, right? So the fundamental goal of the bankruptcy law is to give debtors a financial fresh start from burdensome debts. This goal is accomplished through bankruptcy discharge, which releases debtors from personal liability from specific debts and prohibits creditors from ever taking action against the debtor to collect those debts. Okay, so let's talk about some famous people who filed for bankruptcy in case you guys didn't know. So I understand that people have this, shame or, reservation about filing bankruptcy, but it's really the American way. And it's been around since the concept of bankruptcy has been around since the Old Testament, and it's part of the US Constitution. It's your right by federal law. It's a constitutional right for you to be able to file bankruptcy. So here is the list of famous people: Walt Disney, Henry Ford, P.T. Barnum. Those of you who are old enough to remember Barnum and Bailey's Circus, Marvin Gaye, MC Hammer, Cyndi Lauper, Larry King, Toni Braxton, 50 Cent, all of these people, and dozens and hundreds and hundreds more famous people, presidents, before that guy we have in office now, even presidents like Thomas Jefferson and Ulysses S. Grant has filed for bankruptcy. So you can do your own research to find out more about who else has filed. So Why I bring this up is that all these people on this list are successful people, and they filed bankruptcy, most of them, before they even became successful. And had they not had that chance to wipe the slate clean, they may have never developed the opportunity to become or to achieve the greatness that they did. Okay, so let's talk about the types of personal bankruptcy. First, you have Chapter 7, then Chapter 13. These are personal bankruptcies, not business, right? And Chapter 20 is a term of art that bankruptcy attorneys use for a strategy where you can file a Chapter 7 first, then a 13. So, for the same debtor back to back, and that's a quote unquote chapter 20 that does not exist in the bankruptcy code, but it's just a term of art. Okay, so chapter 7 is the type of bankruptcy that most people who are listening to this lesson are going to need, right? So it's the one that's most common, and it allows a debtor to discharge most unsecured debt. It's a liquidation plan in which non-exempt assets are used to satisfy debts owed to creditors. Most Chapter 7 cases are no asset cases, meaning the debtor's property is protected or exempt from the creditor's claims. Right. So let me explain the concept of exemption. So the whole point of bankruptcy is to give people a fresh start. So can you imagine if people actually had to lose and give up everything, then no one would file for bankruptcy. So there are certain assets that the law recognizes are sacred and that you're allowed to keep. So for example, there's a homestead exemption. And in New York City, where I practice, the homestead exemption is close to $190,000 of equity in your home for each debtor. So if it's a joint case with a husband and wife, that's double that equity. Some states like Florida and Texas have unlimited homestead exemption. So you can have $1 million house and still file Chapter 7 bankruptcy and keep your house. So that's how exemptions work. And that's what protects the debtor's assets. And that's why a lot of people who are savvy and, rich and, upper middle class people utilize bankruptcy as a tool to protect their wealth. And it's sad that, minorities and people who earn lower income are, first of all, not educated about it. And they have all this shame and stigma or feel a way about filing bankruptcy. Um, okay, so moving on to chapter 13. So, chapter 13 is also known as a wage earner's bankruptcy. So, in this chapter 13, the debtor has to have regular income to repay some portion of their debt through a court approved plan within 3 to 5 years. And in this instance, the debtor will keep all their property, including non exempt assets. This is for higher income earners, debtors who have non exempt assets. So let's say you lived in New York, but you have $500,000 of equity in your home. So that would be an instance where Chapter 13 would be more appropriate. Um, and one of the things that's great about a Chapter 13 is that it can be used to protect a cosigner, because once one of the borrowers files Chapter 13, then the cosigner will be protected by the automatic stay as well. I'll explain what the automatic stay is in a minute. So, Chapter 20, like I explained before, it's not a real chapter of the bankruptcy code. It's where you would file a Chapter 7 first to eliminate all of the dischargeable debts like credit cards, medical bills, personal loans, utility bills, things like that. And then use Chapter 13 to be able to manage the student loan debt, right? So this is great for debtors who don't necessarily qualify for the undue hardship discharge. but they can use it to manage the payments for them and make the monthly payment more affordable without going into default and facing lawsuits and things like that. Also, filing a Chapter 13 is great if they want to protect their cosigner. So, the automatic stay is really the beauty of bankruptcy. And this is the law that protects the debtor while you're in bankruptcy, right? So, it protects you from any collection activity and it must cease immediately. So, for example, if your house was going up for auction in a foreclosure sale at noon and you file bankruptcy at 11:59, then that sale must stop and they cannot auction your house. If your car is about to be repoed or if they're doing a wage garnishment, it's literally the minute the case is filed, all of that has to stop. And that's the law that they call the automatic stay. So the discharge is what is the legal term that relieves you of your legal duty to repay a debt. And it's an order from the court to creditors, which prevents creditor from collecting on the debt ever again. So if the creditor comes out of the woodwork months later or years later, they can actually face sanctions for violating the bankruptcy code. So I just want to distinguish between dischargeable debts and non-dischargeable debts, right? So dischargeable debts are the common debts and the things that we think about as of what you would file bankruptcy for: credit card debt, medical bills, lawsuit judgments, car loans, personal loans, payday loans, utility bills, even. So if you owe Con Ed $2,000, you can file bankruptcy and get rid of that, and or even back rent, right? So if you're prepared to move out, or if you've already moved out and you owe an old landlord rent, so all of those debts are dischargeable, so they're going to be automatically wiped out in your general discharge. Non-dischargeable debts are those that get special treatment because of the bankruptcy code and for public policy reasons, right? So that includes taxes, child support, alimony, traffic and parking violations, retirement plan loans, and student loans, right? Because the initial thought when Congress, protected student loans was because it's a public good and we want people to be educated, but we don't want people to abuse the system. And this is before the system became as ridiculous and broken as it is. But I guess they had good intentions, perhaps, but we can debate that in a different lesson. But again, so student loans falls into the bucket of non-dischargeable debts. But there is an exception. So, in most cases, student loans cannot be discharged in bankruptcy. It may be possible, however, to discharge your student loans if you can demonstrate undue hardship. It is difficult, but not impossible. So, if you're looking to discharge your student loan debt, there's an additional step you have to take in addition to filing the main petition. You have to file a lawsuit. It's called an adversary proceeding. So this is where you, the student loan borrower, are the plaintiff, and any creditors that you owe money to are the defendants. Okay? So now let's look at what undue hardship means and what you have to demonstrate to be able to qualify for this relief. So, there are three things that the court looks at to determine whether or not you have an undue hardship. The first is the minimal standard of living. So, meaning if you are forced to repay the student loan, you'll be unable to cover your basic necessities. So, this is just really an analysis of your budget and whether or not you can cover your rent, your gas, your food, your utilities, your transportation, out of pocket medical and dental, life insurance, like all your basic needs, and still have sufficient left over each month to make the minimum payment on your student loan. So if you only, let's say, have $100 left in your budget each month, but your minimum payment on your student loan is $500, then you've met the first part of the test, which is the minimal standard of living. Then the court looks at additional circumstances. So the circumstances causing your hardship are likely to persist for a significant portion of the repayment period, right? So this means that this is not a temporary setback. You're not just out of work for a couple months, or that your salary, you're looking at salary increases and things like that. So also they look at different circumstances going on in your life. So for example, if you have a sick child or a sick parent, or you have an illness where a lot of your disposable income is going to treat these or going for treatments, or if cancer treatments and things like that. I apologize, y'all. I am competing with these sirens and it's driving me crazy. I hope you can't hear them, but I can. Anyway, so again, so additional circumstances that are contributing to your hardship, that are out of your control, and that are going to last for a significant portion of the repayment period. All right. And the last is good faith, right? Meaning, have you made a good faith attempt to repay the loans? Have you, they look at your track record, like how many payments you've made. Even if you haven't made a payment, have you stayed in communication with your servicer? Have you asked for a forbearance or a deferment? So showing that you're trying your best to make the payments or make good on the debt. And also good faith involves minimizing your living expenses and doing your best to maximize your income. Okay. And this undue hardship test is called the Brunner test. And this is from a 1987 case. And you can look that up and learn a little bit more about it. So Brunner, Brunner. Okay, so now that I've taught you that it is possible to discharge student loan debt, feel free to book a free 10-minute discovery call with me on my website, and I can, talk about your circumstances and, whether or not this might be a good fit for you. So please don't be shy, follow up, um, and I would be happy to assist with. With teaching you more about this process. All right, so that's the end of the lesson. So I want you guys to save the dates. I talked about this earlier, but next week, March 12th, I'm going to be doing a live Q&A. And also the registration for the bankruptcy boot camp will open, and I will share more information about the bankruptcy boot camp next week. And then on March 24th, that's when the first lesson, and that's when the boot camp begins. Okay, so I look forward to seeing you all there. Again, you can DM me or email me with questions. This is my contact information, so feel free to follow up if you want a copy of the slides or you have questions. And last, I always have to give you guys this disclaimer. I am an attorney, but I'm not your attorney. So the information provided to you today is for educational purposes only and should not be construed as legal advice. An attorney-client relationship is not created by your attendance here today. All right. Good night, everybody. Looking forward to hearing from you.